Sí, Clio.
Hi. just out of curiosity, just taking your Ava's example, I'm not sure if I got the last part right, because there are a lot of, let's say you have this Nebraska headquarters, and they're selling software, and Ava is, let's say, in Slovakia, for example, she's buying the software, it's not satisfied, it has a legal issue. A lot of American companies also have, created their European headquarters, so that means it's not possible for, let's say, a European headquarter facility of an originally American company to become a legal entity with the same rights that, let's say the Nebraska head office has? Is that possible?
Usually, I mean, you wanna, if you have from the licensor point of view, even though you commercialize your product in different offices, if I were the licensor, I will have all my legal issues in one place. Because I have my legal team, I trust the court, I may have some connections, if you are talking about like a huge company. And on the other side, from the licensee, we are talking about this kind of agreements, as I said before, different agreements is different. You don't have the power to negotiate this. You kind of take it or leave it. So if you want to buy this software, you're not going to negotiate with the internet. You're going to talk to the internet. I'm saying it like in a funny way, but that's the way it works. But if you, let's say you want to develop an ad hoc software for your company, if you're a huge European company, it may be the case you're not going to be clicking on the internet. You see what I mean? That will be a different negotiation, and most probably you want to end up in an arbitration forum in case of conflict. Okay? That's answered your question.
Yes.
Kind of. But that is for free. I mean,
he's a lawyer. He's going to be confused.
That's what I mean.
No, I've read it. Sure. Okay.
Another part, in Europe at least, in most countries, it also matters a lot how the software is sold, whether directly from the publisher or to a distributor. If it's a distributor, whatever the jurisdiction of the software is, in all Europe countries, as far as I know, the distributor is joined at several levels. So you can always, if I have this in your own country, you can always go to your distributor and say, I don't care whether this guy in Nebraska, you give me back money, or you have to take care of me on my ground. Whether software doesn't work, it's secret. So I think it's very important, this variable, whether it's direct or as a distributor.
That's a very good point. Mainly with the explosion in the last, I would say, 15 or 10 years, depending, maybe 15 in Europe and the US and 10 more in Latin America, of the consumer law protection. This is, for instance, in Argentina, you have the Ley de Defensa del Consumidor, that is consumer law that provides that, regardless of what you write in the agreement. So what you're saying is absolutely accurate. I mean, if that's happened, I would say, I say in Argentina. I was going to say something before I start. I can only say in Argentina, even though we are talking about Latin America, most probably most countries in Latin America have the same kind of law, like this consumer law, but you have to double check it. You see what I mean? I cannot talk about other countries because each country has its own law. But let's imagine this will happen in Argentina. You have Article 40 of this consumer law, the consumer, that will say exactly what you're mentioning. I mean, if you buy something, software or whatever, I mean, from a distributor or any intermediary, you can demand, and this intermediary distribution will be jointly liable. So you can do that. So in that case, you don't need to go to Nebraska. If you wanted to find a lawsuit with the licensor itself, you have to go to Nebraska, following this example. But if you go to a distributor, you can do it in Argentina, because this is where the customer or the final client is. The problem that this, or the drawback that it has is, you don't know how solvent or the economic power of the distributor, that you're going to file a lawsuit, you're going to win it, because the software is not working okay, but you're going to end up having a beautiful, the sentence, the court decision, you're going to end up having a beautiful frame, because you're not going to be able to collect, because usually the distributor doesn't have assets. They distribute it, I mean, they collect it. Usually. So in that case, if you want to get the economic result of this lawsuit, not only a sentence or a judgment, you need to go to the licensor, unfortunately.
No more questions? And they are not going to go out in 5 minutes.
Now we're going to go quickly, for maybe some of you are not that familiar with the reading agreement. What is the structure of an agreement? It's a new agreement, but agreement in general, okay? So you're going to have well-written agreement, okay? Something that's kind of messy, but the well-written agreement, even though, as Roberta mentioned, and therefore that the lawyers write difficult, even though the writing is difficult and you have long sentence, that's the report, you will have this structure. In each part, long sentence, okay? Roberta, you're right. And I know that makes it very difficult for you guys that translate, because it's not the same to translate a sentence of 10 words as 100 words. That's what we want. First, we have a definitions section or chapter, where you want to go into the detail of the main terms that may need to be defined with kind of precision. Let's say, for instance, this EULA agreement, you want to define with kind of detail the source code, not explain the source code, but explain what a source code would be, so that the licensee is not going to be able to break it. So it's not that you're going to write against it. The source code cannot be opened by the licensee, but in the definition section, if you're going to write a well-written agreement, you'd rather explain with limited details so the court in the future can understand what a source code is. Imagine a judge doesn't have to know what is a source code. So you have to explain this with a lot of detail. Then you want to include the purpose, it's pretty obvious in this case, it's the license grant and the restriction. When in the restriction you want to explain what the licensee cannot do. Okay? Then you want to be clear, in order to avoid gray areas, that the ownership of the license and the trademark are the licensee. Are obvious, but you don't have obviousness in agreement. You have to write it down. So you have to put it very clear that the owner of the license, of the product developed, and the trademark is the licensor. Okay? Then usually you have a limitation of liability. That will be a limitation that will benefit the licensor and go into the consumer law. Some courts, or usually courts, these kind of provisions read them with a screening willingness. You say what I mean? If regardless of what it says, a court might consider this particular provision null, for instance. Limitation liability will say, in no event, the licensor will be responsible to pay the licensee in case the software is not working properly for an amount in excess of what the licensor collected or get paid from the licensee. Sounds like you're joking. Imagine you're a company, the software that you bought destroy your system and you lost all your clients, I mean the database. The damage is not the $500 that you pay to the company. So sometimes of these clauses, even though are written, when you contest them with the court, sometimes the court considers them null as null. When I say null, it means as it's not written. So the judge is going to say, I'm going to write down what the indemnification should be. Okay, but I have to say to you that it's written.